May it please the court, Ralph Gibson for the appellants. If I could reserve 3 minutes for rebuttal. Sure. This case began in 1987 when Aubrey Wilson died and left a testamentary trust to his wife during her life, Richadean Wilson, and then to his and her then living nieces and nephews and brothers and sisters. They didn't have any children. So when Richadean Wilson died in 2016, the proceeds of the trust were distributed to the then living nieces and nephews. Two of them are my clients. Well, Charlotte Wilson Caraway died thereafter, but she died a year later, and Mary Dell Robertson. The other was was Miss Richadean Wilson's only living niece or nephew, and that was Mr. Greer. So it started out as we filed a will contest. In addition to a significant amount that was in the trust, there was property that was conveyed to Richadean Wilson that was, it's now well after 1987, worth a lot of money in Arlington. And that was to her estate. And it was found that at some point when she was in a nursing home that Mr. Greer had somehow, she just left her will just to him. And so we went through the process of a will contest and ultimately dismissed that. But in the middle of all that, we determined that so many of these embezzlements had occurred in the trust during Miss Richadean Wilson's life, and so also amended the complaint to bring breach of trust issues against Cumberland and the trustee, Ms. Oliver Cobb, and Mr. Greer. At some point, a motion to dismiss was filed, an original one, not the one that's before the court now. Well, it is before the court. They raised it as a cross appeal. And in that first motion to dismiss, Cumberland alleged that a release that had been signed by the beneficiaries meant that there was only, the statute of limitations was only 1 year instead of 3 years. But Judge Gomes found that the 3-year statute of limitations applied because a report had not been made to the beneficiaries that there was a potential claim and other things that were required in that report. That was under the 2016 iteration of the statute. The statute's since been amended, but the 2016 version applies. So Judge Gomes ruled in the plaintiff's favor on that issue. Then Cumberland filed a motion to dismiss, or a renewed motion to dismiss, on subject matter jurisdiction grounds / standing. Now the standing is, don't understand it. It's just pure. Obviously, there's a claim that Cumberland breached its fiduciary duty to the beneficiaries. That could be brought in any court. That's what standing's about. Standing's about not about where you bring it. It's about whether you have a claim. And obviously, they have a claim. So what happened was the trial court conflated that with subject matter jurisdiction and then found that there was no subject matter jurisdiction. Now, obviously, the probate court has subject matter jurisdiction over trust issues, just like the Chancery Court does. And so certainly there's subject matter jurisdiction. So the big problem that Judge Gomes had is that we were still in the estate of Richadean Wilson. Now, obviously, we were in that estate because originally it was brought as a will contest and then amended to raise more claims. So it's understandable why we were in that estate. But to clean that up, we filed a motion to transfer it to the estate of Charlotte Wilson Caraway, or to create a new number, or do something to clean it up if that was what was troubling the court. But it was not a subject matter jurisdiction issue, never was. At most, it was a venue issue, and the venue statute should have been used by Judge Gomes to simply transfer it to a new matter, transfer it to the Chancery Court. She could transfer it to the Chancery Court in Knox County. She could transfer it 400 miles away, but she said that somehow the statute only allowed her to transfer it to a different court, not to a different number or a different estate within the same court. And that's not what the statute says. So the statute's very clear that it can be transferred to any court with jurisdiction. And of course, Tennessee is very clear. The Tennessee, all the court opinions are, we want to have cases decided on the merits, not on some hyper-technical issue, and she clearly had the right to transfer.
Do you have any authority that statute would be applied in the way you state in this type of situation?
You're talking about the transfer statute?
Mm-hmm.
Yes. That is Tennessee Code annotated 16-1-116. And
I know what statute it is. Do you have any case law to support your position on that?
In the N. Ray Salmon's opinion, in dictum, it specifically says that it applies to subject matter jurisdiction. So when you look at what Salmon says, it says, Tennessee Code annotated 16-1-116 provides an original civil action filed in a state or county court where such court determines that it lacks jurisdiction, the court shall, if it is in the interest of justice, transfer the action. Probate action is an original action. And then it says let's see, well, it's Tennessee, it's a Lexis opinion, so star 14 of that opinion. It says, the Tennessee Supreme Court invited the legislature to enact a broad transfer statute that would authorize a court without subject matter jurisdiction over a matter to transfer that matter to a proper court in the interest of judicial economy and in furtherance of the policy of disposing of cases on the merits. And of course, the Shelby County Chancery Court has jurisdiction too. So if she felt like she needed to transfer it to a different court, she could have transferred it to the Chancery Court, even though the probate court obviously has jurisdiction. So if she felt like she needed to transfer it to a different court, Chancery has concurrent jurisdiction. But nevertheless, the statute is not limited to, you got to transfer it to, say, Fayette County Court or some other court within Shelby County. It says a court with jurisdiction to essentially clean it up. And that's subject matter jurisdiction. Of course, this isn't even subject matter jurisdiction. At most, it's a venue. Now, the other issue that's been raised is the cross appeal. And cross appeal, of course, the probate court ruled in the plaintiff's favor. And in the cross appeal, the issue is whether or not the release was valid. And Judge Gomes held, number one, that may or may not be a question of fact, but with respect to whether or not a report was made, one was clearly not made. And so Judge Gomes was correct in denying that motion. I have 4 minutes left, so okay. Can I have 7 minutes, Your Honor?
Well, let me ask you, explain again on this issue about standing. What's your understanding of the standing ruling by the trial court?
Judge Gomes, when in her opinion, talked about how the standing was lost as to well, she didn't say it exactly in these words, but this is my understanding of what she said, that the standing was essentially lost when the will contest was dismissed. As what happens when a will contest, I'm sure as chancellors y'all got these too, but in a will contest, the court determines if the contest is valid and then takes it. You go to the next level. And since we went ahead and dismissed it after we had some discovery, there was no more will contest. So that seemed to be conflated with the other action, which had nothing to do with a will contest or anything regarding the estate itself. It just happened to be sort of almost like pendant jurisdiction in a federal action where it was brought because the parties were all the same, except Cumberland, of course, which was brought in, and Oliver Cobb. But Greer was the defendant, and the plaintiffs were the same as in the will contest. And so I believe that the standing issue was simply confused because obviously the case is against Cumberland for a breach of its fiduciary duty as the trustee. Basically, not overseeing the trust properly and not catching all these embezzlements from Oliver Cobb and then later Mr.
And
Greer.
Are your clients beneficiaries of a trust?
Yes. Yes, they were
Is that
Mr.
disputed?
Wilson's two nieces.
Is that disputed?
No, Your Honor. The only dispute, it's a little confusing, is that Charlotte Wilson, it had to be then living nieces and nephews, but Charlotte Wilson was living when Richadean Wilson, Greer Wilson died. But a year later, she died. So the distribution was made to her. So her husband, Ronnie Caraway, is actually the plaintiff. And Judge Gomes mentioned that, so we established an estate of Charlotte Wilson Caraway and filed a motion to substitute it as the plaintiff, and Judge Gomes never has ruled on that. She's also never ruled on our request to consolidate the estates of Charlotte Wilson Caraway, Aubrey Wilson, and Richadean Wilson. They're all estates in the probate court, but she didn't rule on that, or in the alternative to create a new number, which of course they could do. So that's never been ruled upon. But with respect to the real parties in interest, it's these two plaintiffs. And ironically, Mr. Greer. Mr. Greer has a 1/3 interest in the trust. So ironically, if we win, Mr. Greer, now we're going to raise some equitable issues about that probably, but he's technically a 1/3 beneficiary of the trust. He's just not 100% beneficiary like he thought he was. That's the problem. And then
You've explained the roles of your clients and the roles of Mr. Greer, and I guess the thing I have a problem with is, what's the role of the estate of Richadean Wilson in that dispute or in that ongoing saga there?
nothing. It just ended up in that because it was a second claim brought within the same complaint, like a adversarial proceeding action in bankruptcy or something like that, and it was just never moved to a special number in its own. Obviously, there would have been jurisdiction for sure had there also been a will contest, because it's the same parties in interest, but the case is against Cumberland, so it could simply have been moved to a different number if Judge Gomes wanted to clean that up, but it can be in that estate. I mean, that doesn't affect standing or subject matter jurisdiction. If anything, it's a venue issue, which should be cleaned up, not dismissed. Draconian, that's a pretty draconian sanction to dismiss a case that's over a very, very hyper-technical issue.
Thank you.
Thank you.
Good afternoon, Your Honors. Lindsay Jones of Patterson Bray Law Firm. I'm here with my co-counsel, Austin Rainey.
May proceed.
May it please the court. The appellants have spent much of their time in their brief, as well as much of Mr. Gibson's time this afternoon, talking about getting this lawsuit dismissed on hyper-technical grounds. In reality, this involves two separate cases that his clients have tried to merge together that were never related. On this side, we have the estate of Aubrey Wilson. He passed away in the 80s. He set up a testamentary trust for his wife, of which my client, Cumberland Trust, was the trustee of for the 10 years preceding his wife's death. At that time, she died in 2016. That trust was distributed out to the three rightful beneficiaries, who were Ms. Caraway, Mary Dell Robertson, and Johnny Greer. On this side of the ledger, we have the estate of Richadean Wilson. She passed away in 2016. She had a will that said, "I leave everything to Johnny Greer." Cumberland Trust, on this side, performing its actions as trustee of the trust, which was established through the estate of Aubrey Wilson, was never involved in the estate of Richadean Wilson in any way whatsoever. The two estates could not be more separate. They were 30 years apart in time. They were governed by different testamentary documents. They had different assets. They had different beneficiaries. There were no mutual parties in interest. If the beneficiaries of the Aubrey Wilson Trust wanted to file a claim against Cumberland Trust, they would have had the ability to do that. We have admitted that they were beneficiaries of the trust on this side, but they were not related at all to Richadean Wilson's estate on this side. So to say that these plaintiffs could file over here when their claim was over here seems to be contrary to the principle in Tennessee that every estate involves the assets, the liabilities, and the obligations of a single decedent. Not only that, we have shown that the release alone should have been sufficient to have this lawsuit dismissed. Under Section 1009 of the Trust Code, it provides a trustee is not liable to a beneficiary for breach of trust if the beneficiary consented in writing, released the trustee, or ratified the transaction unless it was induced by improper conduct. Under the Trust Termination, Exoneration, and Indemnification Agreement, the beneficiaries did exactly that. They said on the first page, "We acknowledge that Cumberland has accounted for all monies and property. We have been fully informed of all acts taken by Cumberland Trust in the performance of his duties. We waive any further accountings." It goes on to specifically reference Section 1009. And then finally, it says, "Each party certifies and acknowledges that they know of their material facts relating to the actions taken by Cumberland, and we were not induced by any improper conduct." That on its face was sufficient to have this lawsuit dismissed. If the terms of the release exactly pair up with the requirements of the statute, and we don't give effect to the release, we're essentially not giving any effect to the statute, which is clearly laid out. In addition to that, the trial court erred by not applying the one-year statute of limitations. As I just indicated, the trust termination agreement clearly stated that they acknowledged that they had received the material information and facts necessary to sign that release. Under Section 1005A, the one-year statute, it says that each beneficiary was sent information that adequately disclosed the facts indicating the existence of a potential claim for breach of trust. I just read you the section where they said they received adequate information, and that release was signed June 16th, 2016, which means that the one-year statute would have run on June 19th, 2017. The one-year statute should have applied, and the trial court incorrectly stated that the one-year statute did not apply under applying a prior version of the statute that required a report. The requirement of a report was omitted from the statute, taken out of the statute in 2017, which was 2 years before this cause of action was filed. In addition to both of those reasons for dismissal, these beneficiaries lacked standing in the estate of Richadean Wilson. The court lacked subject matter jurisdiction within the estate of Richadean Wilson, and the transfer was not an available remedy for the court to consider. Standing is whether a particular litigant is entitled to have a court decide the merits of a dispute or of a particular issue. At no point have we said the trust beneficiaries have no standing in any trust action. What we have said is that they don't have any standing in the estate of Richadean Wilson. The Brock case makes it clear that in order for a beneficiary to have a claim against the estate, they must have a beneficial interest under a will, a beneficial interest under a prior will, or be an intestate heir at law if the current will is thrown out. Miss Caraway and Miss Robertson were none of those. They were not the beneficiaries under Richadean Wilson's will. They were not beneficiaries under a prior will, and they were not intestate heirs of Richadean Wilson. They were beneficiaries of a trust that was established 30 years prior, and they received what they were supposed to receive from that trust. The appellants argued that subject matter jurisdiction and standing were conflated. The issue is not that they were conflated, they just were both present. These beneficiaries didn't have standing in this estate, and this court in the estate of Richadean Wilson did not have subject matter jurisdiction to deal with claims of the Wilson Trust within Richadean's estate. And so it's not a conflation of the two, it's just that neither were present. The trial court's order confirmed on 2 separate occasions that the Wilson Trust and the estate of Richadean Wilson were completely separate. That was the basis for finding that these beneficiaries didn't have standing in this cause of action, and that these beneficiaries, that the probate court didn't have subject matter jurisdiction in the estate of Richadean Wilson. If we step back and we look at the appellant's argument, it would indicate that any beneficiary of any estate could file a claim within an open estate in which the statute of limitations had not run, even if there was not a sufficient connection to that estate, and then have it transferred to an estate on which the statute of limitations had already run, which virtually renders the statute of limitations useless. So the transfer statute is designed to allow a court without subject matter jurisdiction to move it to another court. There's absolutely no precedence for moving it from one cause of action in a court to another cause of action in the same court. In fact, the language of the transfer statute is abundantly clear. It says it allows transfers or appeals to any other such court that may have subject matter jurisdiction. It doesn't say any other such claim or cause of action. It says court. The language of the statute is unambiguous, and the most basic principle of statutory construction is to ascertain the legislative intent without broadening the statute. If we take the word court and we broaden it to include claim, claimant, cause of action, we've done just that. We've broadened the statute, and there's no precedent for doing that. The idea that you can file your complaint in the wrong cause of action and then have it be transferred to another cause of action cannot be the law in Tennessee. Otherwise, it would allow claimants to be able to fix their mistakes on multiple occasions by picking a case in which to file their claim, in which their claims can be timely brought. We have admitted that the probate court of Shelby County, Tennessee is, generally speaking, a court with original jurisdiction as it relates to trust and estate matters. I have hundreds of cases that are where the Shelby County Probate Court has original jurisdiction over trusts and estates arising in Shelby County. The problem is the estate of Richadean Wilson, the judge in that case doesn't have subject matter jurisdiction over claimants over here. They had another remedy. They could have reopened the estate of Aubrey Wilson in which the trust was created. It was a testamentary trust created under his will. They could have filed a separate trust action. They could have, as he alluded to, filed a chancery court action. But they didn't, and then they let the statute run, and they said, oh, well, now we should just be able to transfer it to correct the problem. So the issue is not that these beneficiaries could never have standing against Cumberland Trust, and it's not that the probate court could never have had subject matter jurisdiction over this issue. The problem is it's in the wrong case. So in conclusion, the dismissal of all claims against Cumberland is proper. First and foremost, the release clearly satisfies the requirements of Section 1009. Secondly, the appellants did not file within the 1-year statute of limitation, despite their acknowledgement in the trust termination agreement that they had received all material information needed, which was clearly enough to trigger the 1-year statute. Finally, in the estate of Richadean Wilson, the appellants have no standing. They were never beneficiaries or heirs at law of the estate of Richadean Wilson. They were beneficiaries of a trust established for Richadean Wilson for her lifetime. But her estate never had, no assets of the trust went into her estate. She had purely a lifetime interest in that trust. And the law in Tennessee is clear that a lifetime interest terminates at death, and then those assets in the trust were to be distributed out to the 3 remainder beneficiaries, which they were. Richadean Wilson didn't even possess a power of appointment over the Wilson Trust. Her estate had absolutely no connection to the Wilson Trust and Cumberland Trust as trustee.
So let me ask you, so as I understand your argument, you're saying that this was simply filed in the wrong estate, and that it should have been filed either in reopening the Aubrey Wilson estate or on its own against Cumberland on the trust itself,
It could have been, yes, sir.
in a separate cause of action?
Yes.
Separate lawsuit.
In a separate lawsuit against the correct party, because Cumberland Trust has no involvement and never did in the estate of Richadean Wilson. So it's not to say that Cumberland could never be liable to these beneficiaries. Obviously, you know, if this proceeds, we will show that we don't think we did anything wrong as trustee over here. But yes, by and large, you can't just pick an estate to sue that has no relationship to the estate and trust that you're trying to sue. I can't, if I'm
And that's
American.
where the standing issue arose.
Right. If I'm American Express and I have a claim against the estate of Jane Doe, I can't go file my claim against the estate of John Doe because Jane Doe and John Doe were married and they died 30 years apart. And I think that's the crux of the standing issue, is that these beneficiaries of the trust have no standing in the estate of Richadean Wilson.
Thank you.
Thank you, Your Honors.
Your Honor, the problem is the appellees don't understand the difference between venue and subject matter jurisdiction and standing. This at most is a venue issue. The court, obviously, the probate court, the subject matter jurisdiction is whether it has the power to hear this case. And then, of course, standing is, Ms.
As I understand what counsel was arguing is that there was no standing because at the time, once Ms. Wilson died, she merely had a life estate essentially in this trust, and when she died, that was the end of.
That's true.
And so
There's no cause of action against.
between Cumberland and your client.
There's no cause of action.
Between Cumberland and the Richadean Wilson Trust.
We didn't, no cause of action's been made against the Richadean Wilson. The complaint has, as the plaintiffs, Mary Dell Robertson and Charlotte Wilson Carraway, or Ronnie Carraway, her husband. Okay. And then the defendants are Cumberland, Oliver Cobb, and Mr. Greer. And originally Regions, we let them go because they didn't have any involvement. So it's a complaint filed within the estate, just like you might file a complaint in a bankruptcy case that has nothing to do with the bankruptcy estate. It's against different parties. It's just an adversary procedure act proceeding, which is a venue issue. So the estate, the reason that the estate, it was brought within the estate originally was because the first thing we did was file a will contest, which was obviously contesting the will, the second will that we said was invalid, that Richadean Wilson filed, that had. Okay, and then we added the claims against Mr. Greer about, well, in that, we actually raised the claims that he also embezzled money from her estate in that case. And then we learned through discovery that Cumberland had breached its fiduciary duty, and that, of course, Oliver Cobb was all involved in it. So that was all brought within the, so it's disingenuous to say that Richadean Wilson had nothing to do with this. Well, that was why we filed the case in the first place, as a will contest. And she lived off the trust, obviously, for 30 years. So we didn't know anything until she died. But the court can transfer it any way it wants to. The problem is the probate court has subject matter jurisdiction. There's no question about that. It's just transfer it to a different cause of action, or to Charlotte Wilson Carraway's estate, or Aubrey Wilson's estate. It's a venue issue. It's not a subject matter jurisdiction issue. And even if it were a subject matter jurisdiction issue, the Tennessee statute allows it, whether it's subject matter jurisdiction or a venue or personal jurisdiction. All of them can come under that statute. So you have the power to transfer it to either a new cause, a new number. It's not a new cause of action. The cause of action is the complaint. And you have the power to transfer it if you need to. That's what it's about. Thank you.